Welcome to our third session, and our third session will be looking at the application of human rights theory in practice. First, I should start by introducing myself. My name is Phoebe Okowa. I'm a visiting professor in the law school here, and when I'm not visiting, I teach public international law at Queen Mary in the University of London. My task this afternoon really is just to introduce our panelists. The first to speak will be Professor Catherine Sick-Ink, and it will be a joint presentation between Professor Sick-Ink and Jeff Dancy, and they will be looking at the impact of treaty ratification on human rights prosecutions at the domestic level. I think Professor Sick-Ink will speak first, and then Jeff Dancy will speak next. So Professor Sick-Ink is a Regents Professor and the McKnight Presidential Chair in Political Science at the University of Minnesota. I have in front of me her most recent book, The Justice Cascade: How Human Rights Prosecutions Are Changing World Politics. But she's also the author of several award-winning books focusing on US human rights policy in Latin America, and also on the power of human rights norm in the effect of international norms at the domestic level. Professor Sick-Ink has been a Fulbright Scholar in Argentina and a Guggenheim Fellow. She's a Fellow of the Council on Foreign Relations and the American Association for Arts and Sciences. I think over to you now, Professor Sick-Ink.
Thank you very much.
It's up.
It's up? It's on?
Yeah.
Okay. First, I want to apologize to the people in the back of the room for using PowerPoint. If we had known that really the screens weren't going to be big enough for you to see, we would have not done PowerPoint, but we've now, of course, created presentations we're not sure we can do without the PowerPoint, but we have spent time over the lunch hour trying to bold and enlarge every text on the PowerPoints. We hope you can see it, and we'll try to walk you through what you can't see. So first, I want to say that I and many, many other scholars of international relations and international law have greatly benefited from our engagement with Beth Simmons' work and with Beth Simmons as a scholar. So, for example, I think for years people have been making arguments, I and others have made arguments about the positive effects that human rights change in the world, especially involving treaty ratification, involving domestic mobilization and socialization effects. And yet, Beth Simmons' book has really the tremendous impact in the profession that it deserves. And it does so because it really combines the important theoretical contributions, cutting-edge quantitative work using the most sophisticated and the most tough-minded qualities possible. And tough mind, any of you who knows Beth knows that she's her own harshest critic. And so every time you sit here and you give her an argument in some kind of setting, she'll be home running the numbers that night already. My favorite memory is we were on an APSA American Political Science Association panel together, and I sent forward my data on human rights prosecutions for our paper, and Beth plugged my data into her models and ran her models using my data just to make sure that the effects she was seeing in treaty ratification weren't due to human rights prosecutions. And so really just the most rigorous scholar. And not only is she doing rigorous quantitative work, but she also has important and in-depth qualitative work in the book that really supports her quantitative arguments. But I think that Beth would agree if I said that although the empirical evidence on impact of human rights treaties is conclusive, the evidence on the exact mechanisms through which that impact is exercised is not yet conclusive. So this notion that human rights treaties have an impact via these three mechanisms of agenda setting, of domestic mobilization, and of litigation, those may be still more strong hypotheses out there that you show in the book, shows support, but we still need to push those further. And so what I really wanted to do, what Jeff Dancy and I want to do with this presentation is present entirely new work, So this is not work in the book that just came out, The Justice Cascade. This is work that's brand new, and it's work actually designed to engage Beth's book and try to answer what we think are some gaps still in, not just in Beth's book, but gaps in this research agenda, if you wish. And so basically, if you look at what we're learning, of course, that human rights treaties have an impact in new and transitioning democracies. We're learning about Beth's domestic politics theory of treating compliance. And from my own work, I believe we have learned that human rights trials are associated with improvements in transitional democracies. And again, I'm not going to give you this data here. You're going to have to believe me, or you're going to have to go buy a copy of The Justice Cascade, or read really the original article with my colleague Han-Jun Kim, International Studies Quarterly, where we present the evidence of the positive association between the use of human rights prosecutions and improvements in human rights in transitioning societies around the world. Okay, so I believe these are things we have learned. But there are things that so this is kind of a model of what we've learned, and I hope you can see it, but on the far side is human rights treaty ratification. The mechanism is mobilization of domestic human rights and litigation, or in my case, human rights trials, which are connected obviously to mobilization and litigation, lead to an effect on the far side, better protection of physical integrity rights. So this is the Simmons argument in a nutshell. We've heard a lot about that today, so I don't have to elaborate. But here's the argument that I've been making with co-authors, that human rights prosecutions contribute to better protection of physical integrity rights. But there's a problem with scope, and I think this was pointed out in the previous panel. Only, depending on how we count it, 10% to 25% of the cases are these transitional democracy cases, depending on how you count. And so one could say, and I think it's valuable to say, that this is important to know the impact in transitional societies, but it may not be enough. We may want to know more. And then there are these gaps in the overall argument. There's this gap in Beth's argument, I think, still between showing the connection in human rights treaties and mobilization, domestic mobilization. And there's a gap, if you wish, between Beth's work and our work, between the use of human rights treaties and human rights prosecutions. And so what, at this bottom circle here, is the gap that we're trying to address in our presentation today. We're trying to say, what can we say about the link between human rights prosecutions, the link between human rights treaty ratification and the use of human rights prosecutions? And the circle grows. And the big issue we face here is how would we know, and an issue that political scientists call endogeneity, and that is, are treaty commitments and trials both attributable to some missing Z factor? That is, a country has the political will and commitment to human rights, and so as a result, they both ratify treaties and hold human rights prosecutions, but the treaties aren't leading to the prosecutions. And so in our solution to this, part one, is that we split the treaties into three types. And that is, we look at a first, basically the argument is that all of these prosecutions, virtually all human rights prosecutions in the world, are focused on a small subset of human rights, physical integrity rights. Virtually they're all looking at the genocide, war crime, massacre, torture, and to a lesser extent, imprisonment. And so we argue that a certain kind of treaty should be leading to human rights prosecutions. That is, treaties that involve physical integrity rights, that have provisions for individual criminal accountability. As you know, most of the human rights system is a system based on a model of state accountability. States are held accountable in most of the UN human rights mechanisms and in the regional human rights courts. But there are an increasing number of provisions for individual criminal accountability, but only a handful of treaties have those explicit provisions. And we would argue that those treaties include genocide, the Convention Against Torture, the Rome Statute of the International Criminal Court, and here is maybe a more controversial, the Inter-American Convention. excuse me, I'm sorry, the name is wrong here.
Oh, is it?
Yeah, it's the American Convention on Human Rights.
Oh,
The
sorry.
American Convention on Human Rights, and also the American Convention on Disappearances, on enforced disappearances. Now, I'm glad that Rudy Teitel was here and spoke earlier because she made the argument I would have to make, and that is the American Convention does not contain provisions for individual criminal accountability, but the interpretation of the Inter-American Commission, the American Court, has essentially forcefully read in to the American Convention a duty to prosecute. And so we count that convention in this first group because of that move. There's a second group of countries that involve, a second group of treaties that involve physical integrity rights treaties, but they do not have provisions for individual criminal accountability. This includes the ICCPR, the European Convention, the African Charter, et cetera. And the issue here is that these treaties may mention that states have a duty to provide remedies. In fact, and that increasingly it is being interpreted that the duty to provide remedies may include a duty to prosecute using individual criminal prosecution. But we think that link is a much weaker link between the duty to provide remedies and actual provisions for individual criminal accountability. So we count that as a second type of treaty that would be less likely to contribute to prosecutions. And then we have a third category of treaties involving mainly non-physical integrity rights treaties without provisions for individual criminal accountability. And here, I was talking to Catherine McKinnon this morning because, this is a question about CEDAW. Has CEDAW really so forcefully begun to look at questions of violence against women and to encourage prosecution around gender violence that we might think it doesn't belong in that category anymore? So the hypothesis here then is that those groups those treaties in Group 1 will have the strongest effect on the decision of countries to use domestic human rights prosecutions, and the effect will lessen in ascending order. Okay, I'm going to pass it over to my colleague, Jeff Dancy. You should know he's the quantitative whiz, and so he's really responsible for quantitative analysis, which is why it's really great that he can be here to present that piece.
I'm no whiz, but thanks for having me. So I'm just going to go through, hopefully painlessly, the quantitative analysis that we've done based on our quote-unquote solution here. So the first thing that we did is construct composite measures of commitment to different groups of treaties. The groups that Catherine just specified, groups 1, 2, and 3, we made composite measures. What that means is that for each country year in our data set, we divided the number of treaties in each group that the country could have ratified by the number of possible treaties in each group at that period in world time, if that makes sense. It's a lot easier if you just see the way that the number works out, but it's basically how many treaties they've ratified over how many they could have ratified at that time. This yields a % commitment variable that we later put in models. And why do we do this? The reason is that we're treating commitment here as more of a continuous than a series of binary variables that are all working against each other. Instead, we group like commitments and like treaties together into a composite continuous score. So then we select our cases and our dependent variables, which are slightly different, but what we've basically done is gone through all the State Department reports concerning human rights for the entire world over a 30-year period and looked for any evidence of human rights trials. And then after we go through that evidence, we basically filter it for which we consider to have human rights content and to actually be fair trials. So it's a long, arduous process that we've undertaken, and Catherine's been doing it for years and years. I've been doing it for a couple of years with her. So one measure that we use for a sample of all cases, all countries of the world, are all human rights trials. And those are to be distinguished from those that just happen in transitional cases. So we sample only democratic transition cases that have quote-unquote transitional trials. This would show up in the transitional justice data. And then we also just look at all the human rights related trials in the world, not necessarily just in transitional countries. Then for the transitional trials, because these are the only ones that we have this data on yet, we also look at convictions. So what we're trying to do is figure out if these different commitments that we've grouped in the composite scores have a statistically significant effect on the use of these trials net of other possible political and legal variables at the domestic level that would affect these decisions. So we control for things like whether the democratic transition was negotiated or ruptured, if there was complete delegitimization of the former regime or if it was negotiated. What kinds of legal institutions that the different countries have. Obviously, that's going to matter if they have a common law legal tradition, or if they're a very strong democracy versus a very strong autocracy. Finally, we control for other things like structural conditions, GDP, population. So this is kind of under the hood, and this is the part that's more boring. I'm going to just skip through this. This is basically just saying that the type of model that we ran a binary time series logit. You could talk to Jim Hollier about it. He knows deeply these. We were talking about this over lunch. But we could talk about more of the methods issues if anybody's wondering in the question and answer period. What we find is that first, so we'll go through all the findings for the control variables that we included, and then we'll talk about the main findings, the things that we're really interested in. The first are that trial prosecutions diffuse across all countries and across transitional countries specifically. So what this means is if more countries in a country's region have had these types of trials, then they're more likely to do it themselves. This basically comports with other things that we've seen in policy-related research where policies diffuse across different regimes, but we're not sure if it's learning or if it's just copying, but it does seem to happen. Second, countries with ongoing civil wars are more likely to have trials. The finding here is fairly intuitive. Wherever there are civil wars, there are violations of war, and some of those are prosecuted. So we would expect that what happens is that there are more domestic prosecutions in places where wars are being fought. Third, countries with ruptured transitions are more likely to have trials. This does reflect the politics that we've been talking about, the political facet of all these issues. It's not that the human rights discourse has just taken a hold and all politics is left aside. Obviously, there are issues of balance of power and things that are still mattering in places that are instituting trials. And the ones that have the ruptured transitions that have delegitimized the previous regime are more likely to have those trials. Transitional trials also follow civil war victories more often than not. So civil war victories, meaning that either the rebel group or the government group was successful, and we've split those up just to do a robustness check, and basically both are significant. Rebels that won have trials, and also governments that win have trials. De facto judicial independence. This is a measure that we've gotten from Linda Camp Keith, but this increases the probability of trials in the all-country sample, meaning that in those places where there is more de facto judicial independence, there's an independence from the executive, as we might expect, there are more likely to have human rights trials. Finally, the findings that we're very interested in. Group 1 treaty commitment, which is the physical integrity rights treaties with the provisions for individual criminal accountability, inspires trials in all contexts, transitional or not. This happens even when we leave stable democracies and autocracies in our sample. So when we do the sample of all countries, this is still a very significant variable, which kind of works towards this claim that maybe there's this curvilinear relationship where the action is only in transitioning democracies. We're seeing it everywhere. However, and this is more preliminary because it's based on a very small sample of cases, Group 1 commitment is negatively associated with convictions in transitional trials. And there might be a number of reasons for this. One is that these legal processes that we're getting at only produce convictions 5 or 6 years down the road, and we have to look at each individual country year at one time, or that's the way that our model works. But it could also be that this is a process of what we're calling induced enforcement, where countries are being forced to have these trials by both domestic and international audiences, and then those trials stumble or they intentionally delay proceedings and things of that nature. We're still not sure, and we need more research in this area. So one thing with statistical findings that we always have a problem with is that they're just statistical findings. They're just correlations. It could be all these spurious relationships. Somebody once correlated Boston Red Sox batting averages with the stock market and found a statistically significant correlation. So what we were interested in doing is really pushing beyond this And what we did was we just supported it with qualitative evidence. So we went to the cases that we've been reading about and quantifying for years now, and then we looked at the different possible pathways to trials from treaty commitment. One is that there are going to be cases where treaty commitment just doesn't make any difference for the use of trials. We found that in Greece in 1975, before the human rights discourse had become what's become now. Greece still had trials, and they were actually very influential on the process of democratization. After ratification, treaties can serve as a tool for domestic groups to mobilize around, which is what Beth has been finding in her book, and we find this is very strong in cases like Argentina and some other South American cases as well. Treaties and treaty bodies can be a site for outside pressure, which is very much happening in both Serbia and now the newly independent Montenegro. And finally, treaty and domestic law can be kind of complexly intertwined, where both inform one another. Some constitutional or jurisprudential changes will happen at the domestic level, and those will feed back into international law, and it'll come back, and it's a recursive process. And we see this in places like Uruguay. And we could discuss these later in the question and answer period also, but this is qualitative evidence that we have that supports our statistical findings. The takeaway points from all this: first, both domestic and international factors influence the choice to have prosecution. This indicates that there is this kind of a more transnational or horizontal process of human rights litigation that's going on. Treaty provisions for individual criminal accountability appear to be important, and that's something that to this day we're not aware of many people that have been able to show that. And so it might be that our new measure is different than anything anybody's tried before, which is partly true, and it could be just a statistical relationship that we've generated by accident, but we're actually very, very surprised that it was as strong as it was, and it is. And finally, law and politics are intertwined. One of the things that we always hear about is that we're idealists. People will say that we're naive. We're political scientists that want to change the world, and we don't really understand the way that law works. And that's partially true. We don't understand the law as well as people at NYU Law, and we would never pretend to. But we do know that law and politics are intimately intertwined with one another, and that's something that comes out in our models that show both these political factors matter, but also we're picking up this other effect from the international legal developments that have happened in the global constitutional movement. So we'll leave it there, and thank you very much for your time.
I will call now on our third speaker, which is Professor Edward Swain. Professor Swain is Professor of Law at George Washington Law School. He has served as counselor on international law at the U.S. Department of State, and Professor Swain is also published extensively in the areas of public international law, foreign relations law, and antitrust law in numerous journals. The full list you can find on the website of George Washington Law School. And I will call on Professor Swain to give his talk. Thank you.
Thank you very much, and thank you for having me here. I actually have a very extensive PowerPoint presentation replete with graphs, but just in the interest of changing pace, I've decided to not present that and instead to give you a much more impressionistic, much less rigorous account than anyone else has to this point. It's designed to, I think, make everyone in the audience feel better about themselves as being less rigorous than the wonderful presentations we've seen so far. So I come to this, let me just give you a very brief anecdote. From serving, after I was at the State Department, I went as part of kind of an academic as part of the U.S. delegation to an OSCE conference that was on the subject of human rights. And it became rapidly apparent to me while I was participating in this that the concept of human rights to the activists and to the judges who participated in that dialogue didn't mean international human rights so much. I mean, it meant it in the sense that they had resonance in all the international instruments that I was familiar with, but I found myself participating much more as a kind of poor American constitutional lawyer than as a semi-poor, graph-free international lawyer. And I think some of the same puzzlement that I had at that conference came to me when reading Beth Simmons' really terrifically informative work. She engages often on the subject of why international law and why treaties in particular. She directly engages in those questions. She might have simply taken a measure and said, here we have compliance effects, or what she really more rigorously says are behavioral changes, without couching them exactly as compliance. But she permits and she tries to engage on much larger and more interesting issues to international lawyers. If international law matters, as she is claiming in part, we move towards an explanation of why states allow meddling in affairs that they might otherwise regard as sacrosanct. If treaties matter in particular, we have an idea why self-enforcing international law doesn't do the trick or is ignored, why we go forward with treaties at some substantial transactions costs. But what I found in reading the book, which again I stress I just found monumental and incredibly influential, is that her explanations largely revive these same questions in different ways. For the most part, she really has no truck with the kind of conventional international level explanations that international lawyers are particularly fond of. It really is not a theory purely of compliance on the international plane, or even predominantly on the international plane. States are inclined, in her account, I think, to turn a blind eye to violations by other states. They are negotiating these instruments internationally, but the stakeholders exist domestically, and they really don't engage these treaties the interests of other states. So all the action is on the domestic level, really. Not all of it, but the vast majority of it. And so these mechanisms that she describes don't take advantage, in effect, of the absence of clear indications from international politics and describe domestic pathways. That's why we have, for example, the privileging of domestic actors. That's why we have agenda setting. That's why we have mobilization. I want to engage in those and basically ask, so what then is the distinctive function of the international in this? And as a thought experiment in this, just consider several alternatives to this. One is the possibility of a purely homegrown constitution or statute that happens to encapsulate the same substance of the rights. A second is a transplanted statute or constitution that's borrowed from another state, say a rights-prominent state. A third is a model statute or constitution that's developed through some kind of transnational process, sort of a uniform law kind of process. And the fourth is an international human rights treaty, in effect, that is implemented by a domestic statute or domestic constitution, but without assuming any international obligation. So imagine a state, for example, that says, I'd like the content of the ICCPR, or I'd like the content of the Torture Convention. I am going to incorporate those very provisions in my domestic law. That's how much I like them. But what I'm not going to accept is the international obligation to hew to those obligations, or to answer to any international or transnational interlocutors about how I'm performing under those. I like them, I'm going to do them. I promise as a matter of domestic law to do so, but not necessarily as a matter of international law. So in my remaining time, which I'm marching through at a more rapid pace than I envisioned, I'd like to discuss these hypotheticals in a couple of dimensions. One is, to what extent do these mechanisms accomplish some of the advantages that the Simmons book attributes to international human rights treaties, and which serve as predictors of their success, matters like agenda setting and mobilization, for example. Second, are these additional mechanisms, these thought experiments, are they actually mutually exclusive with doing international human rights treaties as we conventionally understand them? That is, not only promulgating the international model through negotiation, but also actually taking an international commitment. Are they competitive? Is there a sequencing issue that we want to face? And the third question, which I hope to get to, is whether the answers to these questions really depend upon whether we adopt a rational actor perspective or a global welfare perspective, and really whether we confine ourselves to the perspective of a would-be ratifying state. I'm going to discuss these at a largely abstract level, but I'll try to bring in a couple of examples. So the book confronts the influence of domestic law in a variety of ways. So, for example, it takes on, in connection with the ICCPR, it discusses the existence of civil liberties as an explanatory variable. And it says this is something that might, explain some of the movement we see in states that adopt the covenant. But it accepts, for the most part, the limitations of the database as terms of the refinement of the local account of what domestic rights already exist and the form that any implementation of a treaty might exist. And so we know relatively little, based simply upon the numbers that get run, about whether the states in question have particular kinds of constitutional rights already in existence or have adopted them subsequent to the ratification of the statute. We know something about that. We know their democracy scores. We know their civil liberty scores. We know things from Freedom House about how well they do generally in terms of promoting some of these values. But it's, by limitation of the data, not anything having to do with her analysis, it's somewhat limited in the specificity. So we know something about this, but we have potentially the fact that there's redundant or complementary commitment to fundamental norms, not so much through international human rights, but through, for example, constitutional rights. This makes it somewhat difficult, I think, to develop causal explanations, but I rather want to explore this in terms of these alternative hypotheses. So, focusing on a couple of the causal pathways. One is agenda setting. So it seems pretty clear that even within a domestic context, there can be change. The relative question is whether some set of conditions makes it more likely that there's going to be change than others. So the argument is, and I think it's a good argument, that human rights treaties provide some kind of exogenous shock because the timing and the content of human rights treaties doesn't lie within any particular domestic actor's control. Therefore, it helps. The need to consider ratification can change priorities and maybe tweak a little bit the set of interests that exists as well. So international treaties jumpstart the local in some sense. So this is a huge advantage over purely homegrown legal change, which we observe, but is hard to accomplish. So it's hard to pull this off. The sweet spot for this is not very large. You want something that is not a complete overlap with the domestic agenda, but not something that's so askew from it that it won't have any traction locally. So it's got to have a certain amount of buy-in, a certain amount of overlap with the domestic agenda and interests in order to pull this off, but not too much. So there's a fair amount of study about how this can occur outside primarily of the realm of international human rights treaties in terms of the transplantation of global constitutions. So the U.S. Constitution didn't spring full-grown from the brow of Hamilton or Madison or anyone like that. It was imported. And similarly, the French Constitution derived some benefit from the U.S. Constitution. There's been a lot of study, and there's recently a forthcoming article by David Law and a co-author, forthcoming in the NYU Law Review, about how effective this has been. The U.S., the snapshot is the U.S. is losing to its neighbors up north and to other emerging constitutional movements. So this occurs, and it is an external spur, potentially. It is, to some degree, a potentially exogenous shock when you have new constitutions like South Africa or India, for example, that can then be emulated by their regional neighbors. This provokes the kind of thing that I think Simmons properly points to. The other mechanisms I was describing really don't exist. The issue, though, is whether the fact that they don't exist means that effort isn't being poured into them, or whether they are just inferior mechanisms for some reason or another. I think you can make a good argument that treaties are better at doing this than the alternative mechanisms I described, but you have to tell a lot of stories in order to get there. And I think you have to make a somewhat more sophisticated analysis of how treaties come about than is easily accommodated within any kind of data-driven model. And so relative to other forms of lawmaking, for example, treaties are fairly punctuated. They permit states to engage in the international negotiation process. They then permit an act of signing. They then permit a further act, potentially of ratification. They then potentially have a further act of domestic implementation, which arguably should precede a ratification, but doesn't invariably. So the beauty of this is you could imagine a gradual ratcheting effect in which domestic actors gradually get pulled into this norms discourse. And the agenda is tweaked, is nudged successively in a particular direction. And I think that's more available to international human rights than to the other methods that I described in the thought experiment. But there are risks to this. And one of the risks is that the iterative process I described will result in plateaus. States will stall out, having made nominal commitments because they were important players in negotiation, because they signed something and then left it hanging. And so, for example, the US is able to derive a fair amount of benefit from being a participant in the Genocide Convention without ever getting around to actually ratifying it for something like 40 years. And other states hang out at that plateau, for example, with the Covenant on Economic, Social, and Cultural Rights. The other advantage that clearly comes to mind is that human rights treaties better engage the executive branch. And this is a point I think that's made very powerfully in the book. I don't know that on balance this is a distinctive feature. It's not necessarily a distinctive advantage because, for example, the realities of constitutional change, which vary dramatically depending upon local polities' rules, can be just as much a deviation from ordinary politics as treaty making can. It can be ground up. It can be referendum based. And so you can have new actors that come to the fore and shift the agendas. The second causal pathway is courts and litigators. I think on this, you can make a very strong argument that international human rights treaties are worse. They simply do not have the ready translation to the experience of domestic law. Constitutional rights are sometimes not to be enforced either. Statutes similarly, but the complications generally are not as profound as they are with enforcing international treaties. So domestic mobilization is a third pathway. It's really difficult here to perceive any generalizable difference between the two circumstances. And so rights consciousness can flow from adopting a statute or a constitution. The examples in the book, for example, are from the US civil rights movement in part. And resources maybe can be galvanized more easily with international human rights, but not necessarily. It's quite possible that the degree of pre-commitment to a constitutional right may be much greater than for a treaty, for example. And so what I think is the missing explanation, or the better explanation in the introductory chapters that is somewhat underemphasized, is the distinctive feature of international NGOs. I think that the focus in the book on domestic mobilization tends to underrepresent the distinctive feature of international NGOs serving as catalysts for this mobilization. That then pulls us, though, back to the international plane and more to the standard account that the book largely does not credit. So, I then promised to say a few words about competition or complementarity in sequencing. Suppose you had a state that was poised for transformation. It's a state where there is an opportunity to influence the domestic discourse. It's not one that necessarily has a robust rights tradition already, but there are some people who want to change that. Should those actors pursue constitutional change, or should they pursue human rights treaties? The answer is probably both. If it is both, then is that answer the same if mobilization resources are low, or there's a risk that mobilization won't snowball? If it is both, still, is there a proper order? There's a lot of evidence on this that I've begun to sort through, but not completely, from Eastern Europe, from South Africa, And the answer has been that neither works terribly effectively, and that it's very difficult in many of these cases to distill one effect from the other. So in South Africa, for example, you have a confluence of events occurring all roughly the same time. You have a change in the priority that treaties are given by virtue of a change in the South African Constitution. So that's sort of a structural change. You have the incorporation of fundamental rights in the Constitution itself, largely aping international human rights instruments in the form of the Covenant on Civil and Political Rights, for example. And you have actual ratification, or signing in the case of the Covenant on Economic and Social and Cultural Rights. You have signing or ratification at around the same time of the human rights instruments as such. So you have structural constitutional change, you have the incorporation of fundamental rights in the Constitution, and you have the actual signing and ratification of a fair number of human rights instruments on the international plane. Which of these matters? Was the order right? It's complicated in South Africa in part because you had a provisional constitution and then a more permanent one, and during that period, some matters were sorted out. Some anecdotal evidence, at least, suggests that the result of all of this has been a relative privileging domestically of the constitutional changes at the expense of direct invocation of the human rights treaties as such. Final point, and I'll quit, I'm sorry. All of this may depend upon which perspective you take on this. So from a rational actor perspective, the question remains, why does it make sense to prefer the ratifying of a human rights treaty as opposed to some other method of adopting the same fundamental norms? So suppose you are a pivotal domestic player and you decide this country needs better respect for fundamental norms. What's your move? If you move in favor of international human rights, the one thing you know you are definitely getting is external constraint. You know that to a much greater degree you are developing a set of principles on which people on the international plane, either NGOs, IOs, or other states, can interrogate you about your fulfillment of these rights. You then need to develop fairly complicated stories about reputation, about simple errors and miscalculation, about why states would want to assume that particular component. If you disaggregate the state, you then start having potentially valuable mobilization arguments that indicate why important players in the domestic process will be influenced and biased towards international human rights. It involves a fair amount of critical assumptions about the affinity between global and domestic interests and so forth. What about a global welfare perspective? Here, I think, the analysis tips much more towards endorsing the traditional international human rights model as opposed to the alternative mechanisms I was describing. It's much more efficient to promulgate one set of instruments. There are network effects that are valuable. You're going to lose some potential adopters because you won't differentiate the calculus, but they can take care of themselves through reservations. I strongly suspect that those adopting a welfare perspective would overwhelmingly favor the very kinds of mechanism that the book addressed. A couple of tentative reactions to that skew. The fact that it's a close call as a matter of a rational actor unitary perspective and less of a close call from a global welfare perspective. One is I think that that's a good reason for a selfish rational actor to look at the advice of international NGOs and other states with some skepticism because of this skew, because of this potential imbalance. But I also think we need to test more carefully, as a result of this differentiation, the underlying global welfare assumptions that human rights treaties are a superior way of conveying some of these fundamental norms. It's quite possible that when states are unable to ratify, for political reasons, international human rights treaties, or might do so insincerely, mobilization might be much more effective if mustered towards the adoption of fundamental norms, such as those precisely stated in international human rights treaties, without first ratifying, and to take that move first. What's surprising to me in part is how consistent that kind of move, committing to the fundamental norms, satisfying domestic constituencies, utilizing domestic processes like courts and litigators. What's surprising to me is how consistent that move is with much of the account in this book. And it is relatively free of a lot of the problems that have bedeviled international law as such. So let me stop there. Thanks.
Our final speaker for this panel is Professor Philip Alston. I think Philip needs no introduction, having introduced himself in the last session. But there are very few academics whose work make national headlines and force governments to convene emergency sessions. Philip's work in the context of extrajudicial killings had just that effect. I think you've had a lot of contact with the bad guys, and who better to speak on the question of putting the theory into practice than Philip himself? I think that's the title of your paper. Okay, over to you.
Thank you, Phoebe. It's a great pleasure to be here. I congratulate the students who have organized this conference. It's an extraordinary turnout and a great panel, great set of panels. I want to pay a tribute, of course, to Beth's book, but I'm going to do it in a very backhanded way. You've heard the great words of admiration expressed for it, and I share all of those. And it has to be said that anyone working in the field of human rights is greatly encouraged, even strengthened by the findings of a work of this extraordinary scholarly merit. But what I want to do is the equivalent of saying, it's a great book, and I'd like to focus your attention on footnote 397. I want to look at one particular aspect, and that is the source of data for studies such as this. Let me go back very briefly, first of all, and say that, of course, the background is to acknowledge the importance of trying to get some sense of the impact of all of the work that is done in the human rights field. The human rights workers themselves are notoriously reluctant to do that for a wide range of reasons. Sometimes they are under pressure from donors. Donors want to see success stories. Success stories are not necessarily easy to identify. It's very difficult to disaggregate cause and effect in this whole area. There are many different actors, many different variables that come together to bring about any particular advancement in the human rights area. So even organizations like Human Rights Watch, an internal study published a couple of years ago, conceded that it has no truly systematized process for evaluating the effectiveness of its project work. The United Nations, where I've spent a lot of time working, is even worse off in terms of really trying to avoid evaluations for fear that they would show unfavorable results. And even worse, a sort of unintended consequence, focusing on the production of variables which can be measured but which might not actually have much impact on human rights. In other words, the number of seminars convened or the number of police trained or something along those lines. So impact is extremely important. There are many reasons why it's avoided by many in the field. The first breakthrough in historical terms came with Freedom House, which produced its reports first back in the early 1970s, started ranking countries for their human rights performance, more accurately for the degree to which they are free. That work was certainly path-breaking, It was, however, subject to fairly extensive criticism. Essentially, Freedom House had and still has its own methodology, which essentially is that it has an analyst in-house or an external consultant who studies a country and produces a report, a range of assessments of how free they are on different scales. They then have a one-day conference with experts and talk about it, and that's it. A country is ranked accordingly. That hasn't stopped the World Bank, in at least some of its work on corruption and other matters, from actually incorporating Freedom House indicators, and a number of other scholarly works also make use of Freedom House's work. But for the most part, at least within the human rights field proper, Freedom House was, and still is, I think, Freedom House does a lot of important work, but in terms of its scale, it is not it's treated more with political importance than with scholarly attention. So there was then a move to set up scholarly databases, which might be a useful reference point. You've got, dating from 1980, the so-called political terror scale, nothing to do with terror as we understand it today, but rather with grave violations of human rights, terror acts committed by the state against its own citizens. Then the Cingranelli-Richards human rights data set, going back to 1981. Then you started to get academics coming into it. Una Hathaway's work, dating from 2002, has been cited many times already today. Beth's work takes this to a whole new level, and of course the work that Catherine Sickink has been doing for many years also seeks to move beyond mere qualitative assessments of impact to try to quantify and actually demonstrate that there has been change and that it can be related to other variables. But what's interesting about all of that more recent work, all the way back to the original political terror database of 1980, is that it all builds primarily on the reporting of the United States State Department. And the question is, what are the implications of that? I'm not here to make a political point. Obviously, there are questions. Some of them have been debated. Is the State Department an objective observer? I think most scholars have concluded that actually it is pretty objective overall, except for a few key countries. I wouldn't rely on its judgment in relation to the following countries that I won't list. But apart from that, it's a good source. But of course, there are questions of objectivity which go deeper than that. It's not so much the State Department, and my apologies to the vast majority of the audience here, but it's the fact that it's an American observer. And Americans, unlike Australians who are politically neutral and objective, bring certain assumptions and prejudices to bear in the way in which they look at issues. It's relevant. Even-handedness. That, again, relates to the emphasis on different issues. It relates to the effort made in relation to particular countries, which in turn reflects different factors. And finally, there's the question of comprehensiveness. How comprehensive are the State Department analyses of a given country? And that's what I want to focus on here. It's going to be a fairly brief foray into that question, and it will come at it from a rather a very particular angle, but I just want to make a simple point. I should hasten to say, though, before I get into this, that none of this is designed to challenge, let alone to undermine, the work done by any of the authors, let alone the two most distinguished by far in the field, both of whom are within shooting distance of me. It's designed instead to raise deeper questions for the human rights community. So the question is, how could we ever evaluate the comprehensiveness, if you like, of State Department reports? I did this for another purpose, but I ran a particular little experiment related to other work that I was doing. I don't want to go into the background in any detail, but in my work on extrajudicial killings around the world, one of the problems that started to confront me was the extent to which states set up commissions of inquiry domestically. As soon as an issue got out of hand, as soon as there was political pressure, they said, it's okay, we've got it under control, we're setting up a commission of inquiry. And when I started in the field, I thought that was a good thing. By the time I finished, I realized that commissions of inquiry generally ended up burying the issues and was a very convenient device for the great majority of governments. But leaving that aside, I then wanted to try to do something a little bit more scientific, so I wanted to find out what we knew about commissions of inquiry around the world, and I took, therefore, this very narrow little focus of trying to find out when there had been a commission of inquiry set up at the national level that looked, among other things, perhaps, or exclusively, at extrajudicial executions, unlawful killings. And in order to do that, I chose the three main obvious databases, which are State Department, Amnesty International annual reports, Human Rights Watch annual reports. And in a moment of stroking my own ego, I took the reports of the UN Special Rapporteur, simply because if you're looking at a specialised field like extrajudicial executions, one would, and they go back to 1982, so it's a convenient comparator, one would think that they might pick up quite a lot of what was going on. The results that I'm not going to present in any PowerPoint form, and of course they're pseudo-scientific at best, because this is really looking through the reports, trying to identify a mention of such a commission and so on. What I found is that these four sources mention a total of 81 commissions of inquiry between 1999 and 2009, so a 10-year period, 81 in total. Of the 81 reports, only 6 are common to all 4 of the data sources. 16 are reported by 3 of the institutions and 16 by 2. 43 of the commissions of inquiry are reported by only 1 of the 4 data sources. So, in other words, and it should be said that the State Department reports won. They referred to more than the others. But that more or less follows because, of course, the State Department is going to be itself significantly influenced by Amnesty International and Human Rights Watch, and even the UN rapporteur. If the UN rapporteur is in a country or focusing significantly on a country, that will appear in the State Department reports, and his concerns or her concerns will. I don't have time to go into this in great detail, but I'll give you one example of Nigeria. In the data set, Nigeria had set up 13 commissions of inquiries into unlawful killings over a 10-year period. Of those 13, one of them was reported on by 3 of the data sources. 3 were reported on by 2, and the remaining 9 were only reported upon by one. State Department picked up one, Human Rights Watch picked up 5, Amnesty picked up 3. Now, there are many reasons for variation. I won't go into those, but I could suggest certain hypotheses. But that's not the point. The point that I want to make is, and this really takes us away from Beth's work onto an issue that I think is of particular importance, and that is what we really need in the human rights field is a far more efficient, reliable, comprehensive approach to global data collection. We need to move to the situation where studies of this degree of scientific sophistication are not forced to rely on State Department data. And I looked at Catherine's justice cascade, and her statement, insofar as she looks at data sources, is a classic. It says something like, well, there's the State Department report out there, the reports out there, they cover a lot of ground and so on. They're not always, I think you say not always, the most objective or the most whatever, but she says, in effect, it's the only game in town. And she's right. There isn't another source of equivalent importance. But what I want to focus on then is that we've got a situation of what Cass Sunstein once referred to as dispersed information. In other words, the information is out there, and if you're a Nigeria specialist, you will look through the reports of each of these different groups and you will pick up what you can. But the dispersal actually has serious consequences in terms of our ability to know what is really going on around the world or in a particular country in human rights terms. I think this gets us into a difficult question of the politics of information. It's not so much the State Department, which is more passive in some respects. They sort of pick up on what others choose to focus upon, not always, but often enough in my own experience. But there obviously is significant politics of information among the large human rights organizations. Could there be some sort of cooperation between Human Rights Watch and Amnesty International? An academic would, of course, say, yeah, why not? Anyone in any of those organizations would, I'm confident, say, you've got to be kidding. And they could give 10 reasons why that shouldn't, or at least won't happen. So I want to finish by saying that, for me at least, this leads to a sort of two-point research agenda. First is trying to get a deeper understanding of the processes that are used and the strengths and shortcomings of the different data sources. There is very little sustained critique of the State Department reports. Very little, I'm not obsessed with critique, sustained analysis of what their strengths and weaknesses are. I come with something of a bias in this sense because I've seen the State Department operating fairly close up in a range of countries. You'll find some 30 references or more to my work in various WikiLeaks cables, and they aren't often because the State Department, having been briefed by me in the field, is then faithfully reporting back on my confidential assessment of the situation. But I think we do need to start looking much more critically, and it would include Human Rights Watch and Amnesty and others. There's a much deeper issue here. What do they cover? Why do they cover it? How do they cover it? What are the biases, either acknowledged or unacknowledged? And secondly, what I'd like to see, but this is a truly ambitious agenda, is some sort of deeper reflection on how we might go about building a very different system. In other words, a system that is less crisis-driven or less episodic than we currently have, a system that is more democratically generated. In other words, we don't rely just on Human Rights Watch or Amnesty International, for whom I have the greatest respect. My work in the field just left me in awe of the work that both of those groups do, but that's irrelevant. They shouldn't be monopolizing the field to the extent that they do in terms of generating information or assessments of the human rights situation. I would like to see more comprehensive information than is collected on the basis of this somewhat episodic approach that most of them use. And I'd obviously like to see a much more diverse range of sources. Where does this leave us? Well, it points in the direction of something that I'd like to at least explore, not here, but in the future, and that is the possibility for building some sort of broader-based human rights wiki-type system where you'd have to work out who is able to make inputs, but you would want to democratize it to the greatest extent possible while maintaining certain standards. You would want information being posted on a real-time basis rather than when Amnesty or HRW has had time to digest a 6-month-long report. And you'd have a much more participatory system with a wider range of actors being able to contribute. Now, the problem with this agenda, of course, is that it's not actually in the interests of many of the human rights organizations that are currently holding sway in the field. So it's really much more a challenge for a group such as this, and particularly for academics. Thank you.
We have 20 minutes when you can field questions to the panelists. Please identify yourself and who your question is directed to. That will make it more efficient.
Thank you, everybody on the panel. It was very, very interesting. I have a question for Professor Alston. My first question is, you mentioned sort of the dispersal of information in the various human rights reports in terms of extrajudicial killings. I got the sense that you found that to be problematic, though you didn't say that explicitly. And the reason I asked that is, do you find that problematic? Because you then went on to say that you, in your sort of ambitious agenda, would like to see democratization of information gathering. And to me, that seems to be suggesting that you think there should be more sources of information. But if you already have a problem with a dispersal of information, I'm just curious how you see those two not being in contradiction with one another.
That's a very good question. I think, first of all, it is problematic. I mean, it must create. I'd be interested to hear both Catherine and Beth and any other political scientist in terms of what sort of problems they think might flow from this dispersal of information, which in this case would, to the extent that many of the academics rely on a combination of State Department and Amnesty, supplemented by Amnesty. But at least my little sample, if it's at all applicable more generally, would indicate that those two sources are actually only picking up on a fraction, not necessarily a small fraction, but some fraction of the overall number of, say, trials, in Catherine's case, or instances of torture, etc., and that one is fairly heavily dependent. So my suggestion then, to make it more democratic, is precisely to overcome the dispersal factor by bringing it all together onto a single website, where you've got the way in which I guess Wikipedia works. I mean, there's a struggle as to how one portrays it, what information trumps other sources of information. But there's certainly an assumption that the democratic process, as carefully rigged, I might add, because in the sort of thing that I have in mind, you'd have to have a way of sorting out who gets to post information, or otherwise you'd have the, let me name names, you'd have the Chinese government agency for human rights information rewriting a great deal of the website. So one would have to work through that. But my argument would simply be that the multiple sources of information, which ideally would certainly include Human Rights Watch and Amnesty, would themselves come together to provide a more systematic picture of what's going on in a given country.
Yes, Catherine.
So first I want to say that actually I with a co-author, have written a whole paper on the topic of, that's a critique of data sources that I will send you immediately. But it is slightly different because my concern is that it is true, all of us are using a couple of data sources. They're all coded from mainly two, from Amnesty International, annual reports, and State Department. But the concern I have is that these sources have become much longer and much richer over time. And so this article is entitled, "What is Good News for the Human Rights Movement?" That is, we have much, much more information than we ever had in the past about human rights violations all around the world. Okay? If you compare a report from 2011 to a report from 1980, when our data set started, they were very thin reports that focused on a much smaller number of rights. What that means is that the scale that we're using when we compare human rights violations in 1980 and human rights violations in 2011 is not a valid scale. Okay? And so a lot of the conclusions that this literature is reaching, that things are getting worse, is because we know more, so much more about human rights than we knew in the past. Now, what I'm arguing is that there are systematic biases in the data, not just arbitrary. And so when Beth finds what she found, and that is that treaties lead to improvements in human rights, she's working against the data. The data is going to make it look like things are getting worse when it's just that we know more about what's happening. And so my concern is more about, if you wish, is this a reliable or valid data, and especially time series? And so what I'd say back to you is that it's so hard, anyone who's worked on data, it's so hard to gather data that there's no way we can go back into the past. Even if we start today with your proposal, we can't go back to 1980 to create a new time series. And so we are stuck in some ways. That's why I say we're stuck. We're stuck with the time series. We're not stuck with what we do in the future. I think we should try to do better in the future, but I don't see how we can ever go back. And so the main thing we should know is these are not objective truths about human rights violations around the world. These are the result of coding of documents that are indeed political documents constructed by organizations that are putting together for other reasons. They may be very good reasons, but they're not. The reason is not to permit valid statistical analysis. And so we should be very careful when we use them.
Okay. The lady at the front.
Ruth Gavison. I'm from Jerusalem. I'm a Strauss Fellow here this year. I agree that impact is critical and that the problems of information are overwhelming. I would add one thing, that there is now a serious beginning of a lot of work done by countries themselves, by human rights organizations within countries that are an additional source, quite important in some countries at least. But even that obviously adds to the complication, because if you're talking about situations of civil rights and the Wikipedia model, if we look at Syria or Libya and we want them to start putting in data about torture and violations of human rights, I think the level of guaranteeing that the information is not itself biased and any kind of ability to assess the credibility of the information is itself going to be very, very difficult. But I want, because of all these difficulties, I want to raise another question that troubled me throughout the day about the question of how successful are we in changing the situation of human rights violations in the world. And I thought that maybe we are missing on the fact that an important distinction is not only international versus domestic and physical integrity with the other things, but also the kinds of processes that create violations that are more amenable to international pressure, like torture, or like actions by governments, or by governments that have a democratic deficit. And problems of human rights violations that are more social in character. And there, for instance, the rights of women that we've heard about in the morning, genital mutilation and things like that, as far as I can see, the presumption should be that it can only be done from within. I mean, international documents and pressures would be totally counterproductive, because the real work that needs to be done is not about a particular act or even a process, but about a social structure or a tradition, and the only way to effectively change that is by mobilizing, empowering internal forces. So I wonder if we don't need to introduce into our impact situation also data and attempts to view changes across accessibility, mobility, opportunities that will give us another task, very different task, but maybe this is not something that we need to add into our attempt to map a way of trying to chart impact and progress in the protection of human rights around the world.
Thank you. I don't know which of our panelists want to respond.
I've got a cheap and nasty response first, of course, which is that the State Department reports, of course, ceased reporting on economic, social, and cultural rights in 1982 as a very deliberate political decision, and have not returned to that, although they are deeply concerned about labor rights, particularly in other countries that might be competing with the United States in certain economic areas. But that's a classic illustration of the extent to which the American perspective on what is important in the world skews the sources of information. But your second point, I'm more skeptical about. I don't believe that change comes entirely internally in relation to many of these issues. You mentioned female genital mutilation. I remember being part of a conversation in 1977 when I was working with a group called the Anti-Slavery Society in London. And there was a very elderly colonel who was running the organization, classic British colonialist type, but with a very good heart, raised this issue. Everyone around the table said, for God's sake, Patrick, we don't want to talk about those sort of things, and we certainly couldn't do it from here. It was sort of accepted, and they started working with local groups and so on. But if you see what's happening in that area today, you can certainly portray it as being a sudden awakening in a whole range of countries to the fact that this practice is barbaric. But you can also see it as having been significantly influenced by the complete delegitimation of the practice at the international level by those groups and international organizations that did take it up after 1977. So I think there is a very important interaction between the international and the domestic, even in an issue as local and culturally based as that.
Professor Simmons.
So I would frame it more, and this is a term that Beth has used as well in her book, as it's difference between where the compliance decision is centralized versus decentralized. And so where the compliance is centralized, it's going to be easier to bring pressure to bear and to get compliance. So, it's easier to end, let's say, the death penalty, or it's easier to give women the vote, because that's a centralized decision. It's harder to end female genital cutting, or it's harder to end torture that can happen in any police station in any part of the country. And so we have to be aware that how centralized compliance decision is will affect how easy it is. But I want to echo, I think, Philip's point that and this a bit in response, I think, to Edward as well, who sort of said it's either domestic or international. And what we're seeing is it's really this complex interaction of domestic international. And we see it even in our prosecutions. Most of these human rights prosecutions are using domestic criminal law. They don't need international human rights law, but they borrow selectively from international human rights law to do a few necessary things for them. They borrow to get rid of amnesty laws because the Inter-American Court has found amnesties to be contrary to the convention. And that's an essential borrowing. It may be just a small piece, but it then lets them use their domestic criminal law. So I think we've got to get rid of this either outside or inside and look at the complex interaction of international and domestic forces.
I actually, if I may add briefly, I'm very open to that, and the structure of the thought experiment was not intended to suggest an either or so much as trying to figure out whether we needed to build in explicitly aspects of international legal commitment in order to distill what the international influence is. And so one of the interesting things is you see countries that are not necessarily part of the relevant international legal process that are nevertheless borrowing concepts from international human rights treaties and from international institutions. And so you see the jurisprudence of ICTY or of the ICC being appropriated and borrowed to fill the gaps as you were describing, certainly in the states that are part of that institution or are parties to the relevant treaties, but also by states that just view it as meaningful and addressing the right kinds of questions. And so the issue is, I think certainly that there's an admixture of the international and the domestic going on. And what I'm fumbling around with is simply trying to figure out how much of that proceeds from the international legal commitment without questioning the value of the international enterprise on the whole, I think.
We have 5 minutes. I think we're going to take our final 3 questions. Please make your questions brief. And
Hi, good afternoon. My name is Chiara San Giorgio, and I work for Amnesty International. I work on the death penalty. And I just wanted to flag a couple of examples of cooperation we try to put together with the civil society and other organizations working on the death penalty to try to collect as many data as possible and maintain a sort of database on the death penalty, which in a way kind of links to the proposal of doing a wiki site on human rights in general. I think there is definitely an added value to having such a database because through different techniques we are able to reach out to smaller NGOs in different countries that may or may not be able to reach out to the international audiences as much as Amnesty International can do. However, I feel like that in most countries there's still a lot of reluctance from NGOs to put their name forward and to come up to the global, say, market because of security or because of other reasons. I think the biggest challenge is always to see who can coordinate such a project and how to make sure that the reliability of the information is maintained. Because sometimes even information that we receive on the death penalty can be has to be reassessed and rechecked with other sources. And that's kind of for an issue such as the death penalty, which is easily measurable, where we can definitely see the impact. Abolition is achieved, executions are stopped. I wonder how that will play with many other issues. We were talking about gender violence, but I feel like it's a massive project, and I think it's definitely a good idea. But it would be good to have, I think, a focal point to bring the project forward, because I don't think it will happen through civil society by itself. But thank you.
Want to respond? Okay. Well, I'll take the next question. We'll take all 3 questions together, and our panelists will have a chance to quickly respond.
My name is Chase Madar. I'm a lawyer, and my question is directed to anyone. We've heard a little bit today about the political reasons that states might have to accede to various human rights covenants and treaties. But to what degree are transnational human rights actors themselves influenced by politics, by geopolitics, and by institutional realpolitik? Are groups like Human Rights Watch and the UN Committee Against Torture carefully choosing the battles they pick with powerful states? Are they being very careful not to criticize too much powerful states under the risk of becoming marginalized, perhaps, and less relevant in the eyes of those great powers on whom they depend in large measure? So how are political concerns shaping the priorities and inflecting the idealistic mandate of the human rights industry today?
Okay. I think there's a third hand up at the back.
Thanks. My name is Emily Hunter. I'm a researcher from the European University Institute in Florence. But I actually want to draw the panel's attention, and particularly Professor Alston's attention, to a data set that the International Criminal Court has established, particularly in response to these needs of democratizing access to information and to reports, and how that works in a collaborative exercise. And in this instance, you have a collection of the majority of reports and documentation, case law, jurisprudence from countries around the world that have been involved in gross human rights violations cases. And I think that this could be useful as a model for you in considering how to coordinate and structure this kind of work. One example would be that there are 14 partners of this project, with around about 250 individuals working to gather and source the data. The data that they source comes from every single agency or organization, including Amnesty, Human Rights Watch, and they're very prepared to share their reports and information on this database, which is freely available for all users. So I think this is interesting for your work, but perhaps also for some of the other people who are interested in sourcing broader data other than the US Department's collection. And I'll say no more.
Philip?
I'd like
Jeff?
to just address the question about the politics of human rights organizations themselves. One thing that we're finding that's pretty interesting, and building on the work of Jim Ron specifically is who I'm thinking of, but what we find is that those countries that are typically considered the Western powers or the powers of the world are the ones that increasingly become more heavily scrutinized by rights NGOs. And that's something that is, or even those countries that are allied with the United States. And so while there was political bias at the beginning of the State Department reports, for example, in the 1980s, that bias has almost reversed itself. And so a lot of the places that the United States is politically allied with are more heavily reported on now. This is something we study a lot, is these different information effects. So to answer your question in a totally different way, the NGOs are strategic, and they are in a marketplace of attention in many respects. And so they do seek attention because that helps with things like allaying donor fatigue and things of that nature, but that is something that's just interesting to study in and of itself, I think. I don't think that it necessarily mitigates the importance of everything that we're working on yet.
So in other words, of course, there's a politics of human rights. People sometimes treat the human rights area as if it were not political. There definitely is a political, but that doesn't mean that the politics of human rights is like the politics of the left and right or any other politics. And so this study, for example, finds that it wanted to see if human rights organizations were pure. That is, did they issue more press releases about countries that were objectively the worst rights abusers in the world? And it found that they were not pure because they issued more press releases about big, powerful countries than about the countries that had the worst human rights record. And then the author said, oh no, they're not pure. And it just seems to be kind of, to me, it's sort of like, of course, these organizations are simultaneously principled and strategic. But their strategy in this case was to push more attention on powerful countries, both the US and China, by the way, than some smaller, less powerful countries with worse human rights records. So not exactly the politics we might expect. And then just finally, on both the ICC and the Amnesty International, I think until we get Philip's big united database, in the short term, I think these kinds of collaborations between organizations and academics can be very, very fruitful. And so I want to make sure I talk to the Amnesty International person. I have a student with a terrific database on juvenile executions laws around the world, and I want to make sure that you folks are in contact. And I want to make sure I talk to the ICC person as well, because yes, we need this kind of collaboration. That's the interim step, is to have, I think, academics collaborating with organizations that are already collecting data and vice versa.
Okay. Well, I'm afraid we've run out of time and we can't take any more questions. I think it remains for me just to thank our 4 panelists for a very stimulating session. And